really pleased to have Professor Anton Burkov. Professor Burkov, just so you all know, is also a member of our International Advisory Board. We have a number of people from around the world who are part of that board. In fact, Susar, Professor Mativa is part of the board. I know that Liz is working with Venkatesh Nayak from India, and I'm really honored to have Professor Burkov aboard, simply because I've known him. Well, Anton, you know our history, but from way back when you published that awesome chapter on ECHR in Russia, and just getting to know you over the years. And I should add on to that is that we're fortunate and similar that we have Susar working. Just so you know, Anton, Susar is from the AUCA that we have that agreement with. We want to do the same with some of Anton's students in Liberal Arts University in Ekaterinburg, and hopefully others as well in Russia. So I look forward to when we can have some of your students here listening to another one of your lectures in English that we could participate in. But really, a real pleasure to have you here. I should add one more thing. Is last year I had the real honor of having Professor Burkov offer us a project for strategic litigation. This year we have fewer students, so the need wasn't as great, but he works on really incredible cases that before the ECHR. I'm sure I'll talk a little bit, hopefully, about it today too. And it might blow some of you guys' minds. Just as one aside, and I hope you don't mind if I say this, Anton, the guy successfully sued Google for privacy violations in Russia. So you gotta love him for that, man. That's really cool. In my eyes, that really raises the status. So I'm gonna let you talk, Anton. Please forgive me. And also, of course, students here after the recording, if we have questions for you, I hope you don't mind if we send them over your way. Other than that, it's great to see you safe and healthy as everybody else.
Thank you. What I wanted to share with you today is my experience in litigating cases strategically with the goal of bringing a social change. And because I'm in Russia, I litigate cases in Russia, we often use this court, the European Court of Human Rights. I don't know, I didn't know how familiar you are with this instrument, with this court. So I prepared this class, this presentation, in the beginning, I will give you a little bit of a background on the court, and then it will help to see how we use this court.
Yeah, that's great. Just so you know, Anton, the students, some of them took the course, Advancing Human Rights Law. Not all of them in this particular course haven't. So that's really great if you get background on the ECHR. That's perfect.
So I started this NGO, Strategic Litigation Center, where we basically select cases which we can take on and carry them throughout all the judicial system in Russia, and then end up, if not successful in Russia, in the European Court of Human Rights. The other goal is to share this experience. That's what I'm doing right now with you. We come up with we work with the media, we work with students, we teach. And because of this, we developed one particular educational tool, which we called ECHR-Navigator. Basically, the idea is to navigate people to go to the European Court. And I will talk about it in more details at the end. So, as you may already know, strategic litigation, or often called impact litigation, has an aim to use specific court cases to develop new legal norms and create sort of broad legal and social change. To make it simple, basically we try to find a litigant at the case, and if we are successful in securing the positive judgment in this case, this judgment will affect not just the applicant, but the undefined number of people. But sometimes it's not even about the victory in the case. Sometimes we know for sure we're going to lose in national courts, but we build the case to raise social awareness about the problem. That's why we call it to win the case in the court of minds. So basically, we can't convince the judge, or a judge cannot be convinced because he's a part of the system. But we reach out to majority of the people, we explain to them that this is wrong, and they take our side. That's also victory. It's slow, but so there are social changes different in different cases, but there is a bigger social change that we sort of pursue is we try to bring international human rights law home, meaning to bring all these guarantees of international law, particularly the European law, European human rights law, to Russia to be used in national courts, not before the European Court of Human Rights. So that's what we are doing since 1998, since Russia ratified the European Convention on Human Rights. So it's a little bit of background. In February 1996, Russia joined the Council of Europe. It was a long process. We were not supposed to be there because Russian legal system didn't reach European standards, but politicians made a deal and somehow Russia joined the Council of Europe, which is a good thing for a regular citizen, because quite often you cannot do anything without the European Court. We cannot do much of a change. And that's just for fun. I put a European anthem. It's funny, it exists in a hip hop version.
1786 as it was written. Up to 1823 it was composed for the first time. 1972 the lady the anthem of Europe. And now 2K3 we got the ultimate remix.
So something like this, you can enjoy the entire anthem when I give you the presentation. So you know this is, I think it's Beethoven. I forgot the name. 1 second. So the Council of Europe, which is different from European Union, it's a political, social political institution, unlike European Union, which is economic union. It has its parliament, committee of ministers, and the European Court of Human Rights, which actually a permanent body since 1998. Just some pictures about the court of the courts. The architect of this building is the same architect who built, I think, Stansted Airport in London. And law faculty of Cambridge University, I think, if I'm not mistaken. Basically, it's international court. It's based in Strasbourg in France. Many Russians think it's Germany because Strasbourg. And it's not Brussels. In Brussels, there is a European Court of Justice, the European Court of the European Union. Sometimes it considers human rights cases, but that's different. Well, there are 47 judges, each from a member state, but they are independent. They don't represent a country. They just selected from the lawyers of the country by the by parliamentary assembly. So the court decides cases based on the European Convention. So they take all the guarantees that they compare what happens in the Russian case, for example, in the Russian case, and they compare it with what is in the European Convention. But itself, the European Convention is very brochure, a very thin document. If you read it, basically you can't understand. You will not know what is guaranteed by the European Convention. In order to know it, you have to read a lot of case law of the European Court of Human Rights. Basically, like in the US, as they say, Constitution is what the judges say about the Constitution. So it's the same here. Some rights that are protected by the European Convention, it's not very much. So the convention itself and some protocols. But quite often, some rights like the right to a fair trial or the right to privacy, private and family life can be very much broadly interpreted. So judges themselves call Article 8, a right to private and family life, a rubber article. So you really can stretch it to cover many other rights. But so what does the European Court of Human Rights do? They apply the convention. Basically, they are the guarantee of the last resort. In order to your case to be adjudicated at the European Court of Human Rights, you have to go through exhaust domestic remedies, go through the national courts, and then, if not successful, to the European Court of Human Rights. And they are very strict about this, about the exhaustion of domestic remedies. That's the main criteria of admissibility of the cases. I like to compare the European Court with the US Supreme Court, because the US Supreme Court is also like a constitutional court of different states. Especially now, when I can see how different states fight coronavirus, it feels like they are completely different states. They have nothing in common. They have no president. They do whatever they want. But unlike the Supreme Court, US Supreme Court, European Court of Human Rights basically have to take every case which comes to their jurisdiction, provided that applicants and their representatives follow the admissibility criteria. The US Supreme Court can pick and choose what they're going to consider, what kind of case, and they don't have to explain. But more often I can see that the European Court of Human Rights is starting to be like the US Supreme Court. They starting to choose, not explaining very much also. It's because they are very, very much buried under the backlog of cases pending for consideration. And mostly because of Russia. Russia contributes 25% of all the cases pending before the European Court. And it gives compensation. And not compensation, not just damages and moral and material damages, but also compensation for legal expenses. So even if applicant was not able to pay to a lawyer and the lawyer works pro bono, you can raise compensation for your work from the government. So I mentioned that you have to exhaust domestic remedy. So Russia ratified the convention, first joined the Council of Europe, then in 2 years ratified the European Convention. The major article, and many people, many applicants, many even lawyers forget that this convention starts with Article 1, not Article 2. I mean, it's logical that every document starts with, legal document starts with Article 1, not 2, which is right to life. Then Article 3 is right to be free from torture. But Article 1 is the most important. It says that those who ratify the European Convention has to protect all those rights in the European Convention, defined in the European Convention. They have to protect those rights within the national legal system, not that the European Court has to deal with all these cases. So in '98, when Russia ratified the convention, everybody thought, okay, we got the right to appeal to Strasbourg, to the European Court of Human Rights, which is completely wrong. By ratifying the convention, everybody get a right to use guarantees of the European Convention within the Russian courts. So that's our mission. So kind of we advance this idea, we advance the social change in the minds that you can use international guarantees in Russia. And we do it through litigating these different cases. That's the strategy that we use. We argue cases before national courts on the basis of European Convention. Sometimes, and I will mention one case today, in some cases, we don't have any grounds in the national law. National law might not protect an applicant at all. So we use the European Convention only. So when doing this, we basically educate judges through this litigation and then through the media. We educate other lawyers who might not yet use European Convention. We educate other applicants. And well, we also do this through trainings. We organized sort of summer and winter schools since 2011. It was offline schools, but and Leonard attended it. It was the last one that took place offline, but since then we are transferring this school online, which turned out to be very timely, taking into account what's happening in the world. Yes, we do publish books, articles, speak at the conference, or give lectures like this. So choose cases. When Leonard asked me, other people asked me this question, the first thought comes to me is that, well, I don't really have any criteria. So if I time with experience, you just see it. When you see the facts and you say, okay, that's the case. So as one of the, again, I refer to judges of the US Supreme Court. I think it was a judge of the US Supreme Court. He said, what is the pornography? I don't have a definition, but if I see it, I can tell that's pornography. So quite often you just came across some facts, some stories, and you're like, wow, that's the case, which can change a lot. And that's very important to choose a proper case, because you, as member of the NGO have very limited resources. You cannot spread your resources around different cases. But the major issue is that this case has a chance to come before the European Court of Human Rights. So you kind of think, in case I'm not success, the case is not. In case we are not successful within the national legal system, we can go to the European Court of Human Rights. And also, because there are some perspective at the European Court of Human Rights, we can use the European Convention at the national level. Well, I wrote this as this issue has never been considered by the ECHR against Russia. That's true, but even better if the European Court never considered such cases. For example, right now we have a case, Sablina and others versus Russia, which is about secret organ harvesting for transplantation. And in this case, we have some issues that we put before the European Court of Human Rights already. We exhausted all the remedies in Russia. We say there was a right to privacy and family life. So basically, doctors did not inform relatives that they're going to harvest organs. They didn't ask permission, consent. So we say that there was a right to privacy violated, and then the religious rights, and there was an inhuman treatment because relatives suffered a lot when learned that organs were harvested without consent. But we also put a question about whether applicants has property rights on organs, quasi-property right, or whatever they call it. You may call it, but it seems to be not right that the only natural thing that we own are our organs. We own it from the birth, or we don't really own them. So this kind of question, and the ECHR never considered such cases. So applicants have a case only if they rely on the European Convention. It's like a very clear-cut cases. Like in this organ harvesting case in Russian law, there is no provision which can help applicants. Under the Russian law, they don't have a right to give a consent. But on the other hand, European Convention does provide this right.
Or Anton, if it's inadequate, right? I mean, if in Russia they would provide some type of protection, but it would be bogus, fake or inadequate, correct? I mean, it's not a black and white.
Well, you're speaking about procedural rights. I'm speaking about material rights. There is no material right to know what is happening with a relative who is in the intensive care unit after the death. So no doctors have no obligation to inform them, the other relatives.
Wow.
So, and these kind of cases are interesting from the point of view of a lawyer, from strategic litigation. This picture of judges with the balances, and you put on one side of the balances European Convention, and then on the other side is the Russian law. And it's the decision is so clear. The ways the decision could be made are so clear, this way or this way. There's nothing in between. There's no gray areas. So by litigating this kind of cases, you can show how the convention is applied or not applied very clearly. It's a good picture to share. And of course, if there's a sensitive case, like organ harvesting case, or we have a case on the right to conjugal meetings between a prisoner and his wife. So basically, it's a right to sex. We have a case on the right to artificial insemination between prisoner lifer and his wife. We have a case where a person was abroad and national police, regional police, threatened him to kill him when he's coming back. Sorry, I don't have enough vocabulary here. Basically, they charged him with a crime, but the goal was not to catch him and put behind prison, behind bars, but they want just to exterminate this guy. So we're filing a case to the European Court of Human Rights, claiming that there was a violation of the right to life, although the guy is alive. Like in Russian law, I'm sure in any jurisdiction, you cannot say that your right to life was violated if you're alive. But we're trying to find this way of saying that the authorities has a positive obligation to secure his right to life, but they were threatening to kill him. So this kind of sensitive, interesting cases that. So there are other questions that I wanted to address here. And of course, we never take any repetitive cases. Well, we take repetitive cases until the first victory, and then we don't pursue those cases anymore. We try to show others how to do the same thing. We give them the roadmap how to do this, how to repeat similar case. Well, choose clients. Well, maybe there are lawyers who has a wealth of similar applicants. In the cases that we're taking, it's very difficult to find any clients. Some clients are afraid to go to the courts. Like with this organ harvesting case, there are very little. The paradox is that every single removal of organs, which takes place in Russia right now, is secret. So every single relative who lost their loved ones in the hospital, who do not know. Sorry, can I rephrase it? So basically, every single transplantation which takes place in Russia is secret. That means that all the relatives are actually potential applicants in this case, but nobody knows that they buried their loved ones without organs because it's all secret. So it's hard to find applicants because nobody knows what's happening. But if we find somebody, some people just do not want to go to pursue this kind of case, although we offer our help for free. But I must say I'm quite lucky with applicants. They're usually very good and supportive, and they're willing to talk to the media. Sometimes the client may be, of course, difficult. For example, a few months ago, this wife of a lifer who is a litigant in the case of right to artificial insemination, she is in touch with me, but when a journalist is offering an interview and trying to approach the applicant to discuss whether we will give an interview or not. And she is absolutely irrational sometimes and doesn't want to talk to me. So I'm trying to take it easy because it's her private life. Of course, we're losing some opportunities here to speak about this case.
Hey, can I ask you another thing, Anton? Is that okay?
Yeah.
And it's relevant because it was part of the end of a lecture that I was giving, I think 2 weeks ago, that I promised to finish up, which I never did. And one of it was trying to bring across the point that, and I shall, by the way, one of it's bringing across the point of how, strategic litigation, and certainly the cases you're talking about here, and of course before the great ECHR, where there's hundreds, thousands of cases, clients shift, needs shift, desires change. I'm wondering if you've ever come across that, and if you have, how you deal with it. I'll just give you one example. If you have a case, let's say with artificial insemination, and if they're waiting 10 years, and then all of a sudden the woman might be 45 or 50, where it might be a bit dangerous to be artificially inseminated for the baby, for her, or maybe they get divorced, and there's no interest in continuing with conjugal visits. Maybe you could just comment to the students a little bit about how you might deal with those type of issues. Can litigation, does litigation continue anyway in those type of instances? And I think that would be very insightful, if you don't mind, if that's okay.
Well, with this artificial insemination case, the first case like this we had in 2004, and we lost it in the Russian Constitutional Court back then. And we wanted to appeal to the European Court of Human Rights, but we ran into trouble with admissibility criteria. And so the case was not accepted, but also the couple broke up. That's learned us to have multiple applicants on the similar cases. When we got another applicant in 2014, so 10 years later, I sort of learned from this mistake, and I had 4 different applicants, 4 different families. And luckily, all of them reached the Russian Constitutional Court, and the court has changed its opinion, which it had 12 years ago. In 2014, we won a case at the Constitutional Court where we were able to secure the right to conjugal meetings, but not the right to artificial insemination. So now this family has they have a conjugal meeting once a year, which is not much, but that's something. And that's the positive thing about trying to apply a European Convention domestically, because we're still pending, they are still pending, waiting for judgment of the European Court of Human Rights, but they already, for 4 years, they already have conjugal meetings. So, of course, it doesn't really help with natural insemination. They still need artificial insemination. If an applicant, if at the latest stage of the consideration of the court, European Court of Human Rights, of the case, if the applicant, for example, lost interest, let's say they separated, the European Court of Human Rights has a right to continue considering this case by taking into account the importance of this case, strategic importance of this case for other potential applicants. Of course, they don't award any compensation in this case, but they decide the matter on the merits. So Sablin, I mentioned Korolevs versus Russia. That's the case about artificial insemination. Sinikov versus Russia. That's the one I said about, right to life without being killed yet. Plastic pipes versus Russia is interesting in terms of we defend here an entrepreneur whose factory was actually stolen from him, physically and and juridically. It's a factory of producing plastic pipes, and the investigator claimed that this particular production line wasn't really a huge factor, but the line $500,000 of cost. The investigator said that this line was stolen, and this is a object of the criminal case, and they confiscated it, and then it disappeared. So basically, the owner of this factory, this production line, is suing government for damages for losing this $500,000 plant and what is it? Every income it would have had if the factory was producing. So that's a lot of money. And then Basok versus Russia was interesting in terms of basically the guy was hit by a major traffic police officer, the head of the traffic police of the entire region. He was taking pictures how this police officer was violating traffic rules as a major traffic police. The guy didn't like it. The police officer didn't like it and hit the journalist into his camera and his eyes. There was a criminal case, but then at the last moment, the prosecution dropped the charges and nobody asked an opinion of the victim. So they just closed the case. So we thought how we would go to the European Court of Human Rights. And from this point of view, it was very interesting because a victim of a crime doesn't have any rights under the European Convention. Only the accused of a criminal offense has a right to fair trial, but not the victim. So we couldn't go to the European Court of Human Rights claiming a fair trial violation. But we decided to go and claim the right to freedom of expression, freedom to collect information and then use it to express the opinion. So he was not allowed to collect information. Instead of information, he got a punch into his eye. That was interesting to save this case, because this case was not made for the European Court of Human Rights, but we made it for the European Court. So the strategy that we use in particular case when we litigate, we put this obvious question before a judge, as we say, two balances, two sides of the balance, European Convention, national law, and the judge has to decide. And in Russian law, if national law contradicts to the European Convention shall prevail. So it's when you put this clear picture, you know what the judge has to do, and the judge, because as a part of the legal establishment, they don't want to decide your side, your way. So they have to come up with some kind of explanation why they didn't apply the European Convention. And that's where it becomes very interesting, because they make a lot of mistakes. They made up some kind of grounds, and you collect them for the European Court of Human Rights, as we call it, to sue a case, to make the case for the European Court. So we package it to this reaction of the judges for in the application to the European Court of Human Rights, and wait for decision.
Yeah, I just was gonna, if you don't mind, sorry, Anton, I was gonna throw in there also I really like your first point about the obvious question before the judges, because that's relevant not just before the court, but also before the public, before community activists. It's so important to couch the issue in a simple yet effective manner that it could become a banner, you know, it could be, you know, it could become something that could be utilized not just before the court, but also in other engagements that you need to do for strategic litigation. Sorry to interrupt. I just wanted to point it out to the students as well. It's a really
Yes,
important
and
thing.
we put this question to the media. Sometimes we get a good coverage. The organ harvesting case, although we didn't have any victory yet, we already have 2 articles by Associated Press. When we lost the case at the Russian Constitutional Court, I think in my career, I had the best media coverage after losing this case, not winning. Well, Google was very popular, but I didn't ask much money from Google. I should have asked more.
For sure.
So we teach and publish our experience. That's why we run this URL's International Human Rights School, and now we went online. This also helped us to find other applicants. Because of the exposure of this subdomain case and organ harvesting, I found 5 other applicants. Well, potential applicants. Only 2 of them decided to pursue the case, but at least we have some data what was happening. So that's the conjugal meeting case. Do we have time?
Yeah, I'd say you have another like 5-10 minutes of talking. Is that okay?
I'm gonna go very quickly. I already mentioned that.
Hey, just a quick question for you, and I hope you don't mind. It just hit me. I'm sorry if I ask you this about the organ harvesting, and I know you've been working on this, and we've been talking about this for like 2 years, but it just hit me. You know, it might be interesting to look into the religious communities that exist in Russia. For example, in Islam, you're not really allowed to, if you want to understand about Islam, you're not allowed to organ harvest, and you can if there's reasons for it and this, that, and the other. But it might be really cool to start engaging some of the religious communities and see, you know, maybe there's some imam in Russia who's like really adamant for this, and it might open up some more avenues for you. I'm just, you know, throwing it out there. Anyway, sorry, it just hit me as we were talking, and I know we've been talking about this for years, so forgive me, but.
Yeah, we tried to engage Orthodox Church, Jewish people, what's the name? But it's also resources. If we have little resources, you prioritize your legal, what you have to do in a legal case, but then journalists, and then maybe some other. So conjugal meetings and artificial insemination. As I mentioned, so basically there's a Russian law which says that if a lifer doesn't have a right to any long-time meetings with their relatives for the first 10 or more years, and even the time is not defined, minimum 10, but it can be 15, 20 years. They do not have a right to conjugal meetings. No explanation given why. Of course, they might be very, very dangerous. So we had this first clients, the Harkins and Khorosheko, in 2004, and we lost this case. And the Constitutional Court, you can see what it says, may be limited in the possibility of having a child or family life. Basically, what they said, if you are convicted for a crime, you lose everything. It's not just you lose freedom of movement and do whatever you want. You lose your family life. But then in 2014 we got this new applicant, the family of Korolevs. You see them on the pictures. They married in the prison. They knew each other before he was convicted or even committed a crime. So in 2004, in 2004, we pursue a case on the right to conjugal meetings. We didn't speak about artificial insemination yet, but because we lost it, with the new applicant, we decided we had to rephrase it. We did this case on the right to artificial insemination. There was no reason to apply again for the right to conjugal meetings because the Constitutional Court already issued an opinion. So, and we lost this case in 2014 in the district courts in the appeal, and then suddenly we got this grand chamber judgment of the European Court of Human Rights on the Khorosheko versus Russia. It's a very similar case. That's the guy who also lost the case in 2005. He's on the picture. So he reached, actually, unlike Zakharkin, he reached to the European Court of Human Rights, and his case was admissible. Sometimes applying to the European Court of Human Rights is like a roulette. So Zakharkin, in this case, his case was not admissible, but the case of Khorosheko was admissible. And I actually met a lawyer of the European Court of Human Rights, already a retired lawyer. And he told me that he was in charge of Khorosheko case. And this case was supposed to go to the bin. But he wrote a very good opinion, and the judge decided to move on with this case and even send it to the Grand Chamber. So it's just up to a lawyer which considers a case. So, in this case, in Khorosheko, European Court of Human Rights said, this is a violation of family and private life. And even two judges said it's a per se inhuman treatment not to give a right to conjugal meetings. So we took this case and applied to district courts again, but we asked for the right to conjugal meetings this time. We almost won at the district court, which was a kind of a surprise to us. It was a very good judgment, but it was quashed on the appeal in the Moscow City Court. And we went to the Constitutional Court. Yes, and we engaged three more families. I found Andrei Khorosheko. I convinced him to apply to the Constitutional Court as well, and to other families of lifers. So the Constitutional Court ruled in favor of the applicants, which was important because they had to change their own opinion, which was 12 years old. And it's very difficult to convince a judge to admit the mistake. Although in the judgment, they didn't say that they made a mistake back then. They said, since then, there was a lot of changes in the international law, new judgments of the European Court of Human Rights. So we have to rule according to the new legal norms, which was fine. But unfortunately, they didn't consider the case, so this case was kind of a two-sided, the right to conjugal meetings and the right to artificial insemination. Our application touched both rights, but the European Court of Human Rights, the Constitutional Court completely omitted the facts which led to the right to artificial insemination. So that's why we have a case now before the European Court of Human Rights, mostly on the right to artificial insemination, but also on the right of conjugal meetings, although we won it, and they got this rights, they visit every year, but because they didn't get any compensation for 10 years of no meetings. So in this case learned me that strategic litigation goes beyond just strategizing litigation, like what case to choose, what applicants to choose, how to work with the media, how to file a case, how to give interviews, how to work with the media. It's also about organizing people, organizing other applicants, and educate them. You know, all these families, I worked only with Korolevs, but to others, I just coached them. They are not lawyers, but I coached them. I was able to teach them how to bring a case, how to go with this case through all the courts in Russia and reach the Constitutional Court. Well, sometimes it's up to an applicant. You have to have some abilities to do this, but they were all good, and of course they got a lot of help and a lot of writing from me, sort of a lot of forms they just needed to fill in, but they spoke at the court themselves, they argued, it was fine. And of course, I never, some of them I never met. There's Alessia and Oksana Matsinini, the picture below. This one, I never met them in person. It's all was done by internet. I met those couple in person. Yes, I already mentioned this. The consequences of the Constitutional Court judgments, all the 1,080 lifers and their relatives received the right to conjugal meetings. They changed the legislation now, all those people has, and they started to build dorms to accommodate, because before they didn't have enough, they didn't need a lot of rooms to fill in, to be used by those who are claiming the conjugal meetings rights. And this is Veronika Koroleva went for her first conjugal meeting. We are at the airport. I didn't go with her, of course, but I just took her to the airport. So how this 2014-2016 litigation was different from 2004? Yeah. So many families united the effort to bring similar cases to the attention to the Constitutional Court. They all went through different courts in different parts of Russia and met at the Constitutional Court. So we showed at the Constitutional Court that this issue is important. It's not just Koroleva and her husband who was convinced for this terrible crime. There are other people, and most importantly, not prisoners are suffering, but the relatives who didn't commit any crime. They didn't lose their right to private and family life. And it was possible for lay people to argue cases with our coaching support. So, and I started to think, what if we do so in every important case we litigate? What if we create an online tool to assist them? And it's in two kind of ways: to assist in particular cases and to assist lay people in general. And maybe not even lay people, but some advocates, some bar members in Russia have no idea how to apply to the European Court of Human Rights, and we can coach them too. They, in this regard, they're like lay people. They have no idea how to use the European Convention in Russia or how to go to the European Court of Human Rights. And this is a statistic which comes from the judges of the European Court. 60% of all the applicants which go to the European Court of Human Rights, are not represented by lawyers. Only 40% are represented. Wow. But even those, I asked the judge of the European Court, are those 40% bring better quality applications? And the judge smiled. She said, no, it doesn't really help. It says that even the lawyers who help somebody you can't really say it's help. It's, if you don't know how to do this, it's not help, it's ruining the case. 15% of all those cases end up in a very early stage. They don't even go to the table of the judge. Filtering section send those applications to the bin because they just simply were not filled in correctly. So it means it's not even inadmissible, it's just not an application. And the two major mistakes: exceeding the application size, can I say size? So they write too much. Although it's PDF form, how you can fill in too much? You can't fill, but they found a way to do this. Our people are very creative. And they do not sign applications.
Wow.
Even lawyers. So as a result, only 5%. So the other, so it's 15%, and another 80% end up as not admissible because lawyers, applicants, they do not respect admissibility criteria. So only 5% of all the applications, they actually reach a judge, and the judge considers it's on the merits. And one can avoid 15% of the mistakes by following just 2 hours of online course. If you give just a very intense course for 2 hours and explain how to fill in the application, it's guaranteed no 15% of the mistakes. So that's why we decided, and we claim if you undergo the entire course, which is 5 classes, you can avoid 90% of the mistakes. And then 5% is up to the judge. So that's why we created an educational project on fully 100% online, like your program, ECHR-Navigator. So the idea is to navigate, right, the person. You don't take the person to the European court. You don't prepare an application for the person. You don't act as a lawyer. You just show how to do it yourself. It's like cooking class. So the mission is to avoid these mistakes. Less serious, more serious, it doesn't matter. They're all the reason for the case not to be considered on the merits. Yeah, that's it.
It's
So
really cool. You
now
just, oh,
we
sorry.
are, for half a year, we were running this classes, online courses. It's developed more than into a set of lectures, set of coaching classes, but also there are a lot of tools that we created so people can just read and do it the right way. We very rarely take cases for us to litigate. We try to spend our resources to show other people how to do it. You wanted to ask?
No, I know. I just wanted to say is that I wanted the students to be aware of what you're doing, like in terms of, it's like creating like it's just really cool. I want to be aware of it's just creating like an kind of like an online capacitating through the use of the online platform for people to engage the ECHR, which and it's all in Russian, which is really it's surprisingly fresh. Yeah, I can remember we were talking about it, and I was saying, I can't believe nobody's done that. And you go, yeah, that's what you have to do it.
When we started to do this, I came with a background of an NGO. So I'm skilled in applying for funding, running projects, but I never was trained how to sort of show to the people that they have issues and to make them aware that they have issues, and this is how I can help. So these courses that we created, they're not just lectures. Like, for example, like today, basically, right, what I'm doing right now is lecturing. Right? I'm talking, you're listening, you might have questions later on. But in our courses, that's why we call it coaching. It's not only talking, it's also giving them documents as an examples, giving them forms, showing them. Basically, we try to structure our classes. We give them chronology, when to do a particular step, and then we showed how to do those steps. We give them examples, sometimes even forms, which they will have to just fill in and explain the rules. So basically, by the end of the course, they should be able to do it themselves.
Very cool.
Yes, if you want to read more in English, that's the recent, it's already 2 years old, which is not very old, a chapter in the book where I showed how we litigated those cases that I mentioned today. It's in English. And those cases are still pending. Like 2 years ago, I wrote about it, and they are still pending before the European Court. It's too long.
Nice.
Thank
you so much.
If you want to volunteer, you can pick a case. And with the previous students of Leonard, we are working on the Sabliner case. Well, not the Sabliner case, but the follow-up case. And Bill Alman is now helping me to edit. He did some research. He helps me to edit the application in English. He's actually attending my talk on Wednesday.
Yeah, in fact, I'm going to say two things to that. Thank you. One is, I actually meant to say at the beginning, thank you, Anton. Absolutely, if there's any cases that pique interest of any of you all who are watching this, or you have colleagues who are interested, contact me, or even better, contact Anton directly. Yeah, I mean, the students do great stuff. You mentioned Bill Allman. He started off in I think it was in the 511 course, right? Strategic litigation, and now he's continuing with you even after graduation. And Anton's a great guy to work with, a wealth of knowledge, but also really, as you can see, pretty wicked cases. So thank you for reminding me about that, Anton. That's really important. I also will say is, and this is just a plug, I already put it on the Facebook page just so you know, Anton's going to give a guest lecture Wednesday, I believe at 12 p.m. Eastern Standard Time, through Zoom in Harvard Law School, where he is now a Fulbright scholar, which is actually quite impressive in its own right. And it's even cooler that he's giving a lecture there at Harvard Law School. So just so you all know, I posted that link, the Zoom link, up on the Facebook page of the graduate program of the Master's Human Rights Practice.
To my talk?
Yeah.
I'm not sure Harvard would like a big crowd, but.
Oh, really?
Yeah.
Oh, right. Well, don't worry.
I don't know. Well, they asked me if people can RSVP.
Oh, they did. So whatever. So if the students could RSVP,
but if you guys want to attend, yeah.
They could write to you maybe. I mean, I don't know how many students will, but if there are students, you all can contact me, and then I'll push Anton to say, please, please, please. And, we'll work that out. And if not, we'll bring an action before the Council of Europe for discriminatory action between Harvard law students and University of Arizona human rights practice law students. So,
did you
that's our
get
next
this link
step.
to my presentation?
Sorry?
I just sent in the chat, I sent the link to this presentation. So
Oh, brilliant. Thank you. I'm going to cut and paste that. I appreciate that. Thank you. Yeah, it's really bizarre on the Zoom, just so you know, during the chats, if I end the meeting, I lose the chats. It's really bizarre. So I'm just going to make sure I've covered it. Don't worry, I cut and pasted it. But in any case, thank you. This was great, as always. And I really appreciate your time, Anton. I really do. And they'll have the other couple, we have 7, 8 other students who watch it as well. And as you know, they'll probably come back armed with questions and comments. I hope that's okay. And stay safe. Enjoy the rest of your time in America, even though it's under quarantine. But at least you get to look at the 4 walls of your apartment. You get to do a lot of touring around,